Well, I'm Bill Whitford. I'm a retired law professor from UW-Madison, and I'm one of the 12 plaintiffs in the case. My name happens to be listed first in the complaint, so the case has got my name on it, and hence I'm called the named plaintiff. I've been involved with the case since, I helped get it started in looking for lawyers, so I've been involved in the case for over 4 years now. There's only two tricks. They're called packing and cracking. And those sound like slang words, but actually they're used now in the academic literature. The justices talk about packing and cracking. They're become terms of art. But it's not very complicated. Supposing you're a Republican legislature and you want to create a Republican gerrymander, one that essentially guarantees the Republicans a majority in the legislature regardless of how many votes they get in the state. What you do is you take the Democrats in the state, and you can use election statistics to identify who they are, not individually, but by where they live, pretty accurately. You take them and you put them in supermajority Democratic districts. That's called packing. Over 65% Democratic, predictably. And these predictions are pretty accurate. Then you take the remaining Democrats that you haven't managed to put in a few packed districts, and you spread them out kind of evenly. So they're like 40 to 43%. And not so many that they risk winning a majority in that district, but you spread them out so that be careful they're never a majority in the districts. That's called packing. So those are the two techniques. Packing as many as possible in supermajority Democratic districts. Cracking, spreading them out kind of evenly. So there's a substantial amount in each, because there's a lot of Democrats in Wisconsin. There's a substantial amount in all those other districts, but never a threat to take them.
How did that happen?
Well, there have been other gerrymanders in Wisconsin, but this one was done that way. These days, computers are used in redistricting, and you load election data into the computers so that, and then you actually draw the maps kind of on the screen the way you would, like this, and it creates some lines, and the computer will kick out, well, that district will have this kind of orientation politically, that one, and you just go around experimenting like that to see how many packed Republican districts you can get. But your techniques are packing and cracking. I don't know if the camera will pick this up, but I have a little map here of Milwaukee and Racine before and after. Can we do this,
Sure,
Mark?
absolutely.
This is right out of our brief, and it's how it's explained in our Supreme Court brief, but these areas are west side of Milwaukee and Waukesha County and Washington County. That's the west side of Milwaukee and some suburbs to the west of Milwaukee. These are roughly comparable areas. You can see under the previous apportionment, the blue are Democratic, the red are Republican, and there were 4 Democratic districts and 4 Republican districts in this area. By packing and cracking, they created 2 Democratic districts and 6 Republican. And what they did was to take these areas in the west side of Milwaukee that are Democratic, and instead of making them districts, they made these east-west districts. You got about 40% Democrats, about 60% Republicans coming from Waukesha County, Washington County. So that's cracking. And this is Racine, Kenosha. Now this is the old map. You had 2 Democratic districts and 1 Republican in Racine County, 2 Democratic districts and 1 Republican district in Kenosha County. So they combine the counties, create 3 Democratic districts all along the lake shore, and 3 Republican districts. This is packing. These are highly Democratic districts, highly Democratic. And these are less, these are cracked. These are 55 to 65% Republican. These are like 75% Democratic. So they created what was 4 and 2, 4 Democratic, 2, there's now 3 and 3. And that happened all over the state, so it just adds up. Well, the Republicans in 2011. The Republican leadership, I should say, in the legislature adopted an unusual procedure for drafting this current apportionment, which we call Act 43. And what it was designed to do was to keep the whole process highly secret, so that nobody knew what was going on until the very end, when it was sprung into the public and enacted in the legislature within about a week. Not even the rank and file Republican legislators really knew what was going on. And the technique was to keep it secret because, you know, in Wisconsin, legislative hearings, everything's in the public, you know. They hired lawyers to draft the legislation and then took the key aides, legislative aides, who had the political knowledge and the ability to draft plans, political knowledge to draft them, and made them employees of the lawyers. And they were trying to keep it secret by saying it was all within the law firm and what's called lawyer work product, which doesn't have to be disclosed. But an earlier court said that's all BS, pardon my language, and we could see it's just subterfuge. And they demanded that a number of the documents be made public, were really turned over to the lawyers of the plaintiffs in that earlier case. But they'd be available to be introduced in court then, and they would become public. And what happened is that the Republicans dilly-dallied, and basically they didn't turn over everything they were supposed to. And they got caught at it, and how they got caught is an interesting story, a long story. But once the court found that the Republicans were playing funny business with that, they'd already endured all the arguments about how it's lawyers' work product, and they said that's nonsense. It's legislative work product. You have to disclose it. And then they didn't just turn it all over. The court just threw up its hands and said, "You give the plaintiffs' lawyers an image of the hard drives," which they did. And one of those lawyers was also a lawyer in our case, so we had that image as the hard drive. And as I said, a lot of the stuff had been erased. We're not exactly sure how, but or I'm not at least. But a forensic expert could recover it. They hadn't deleted it effectively, essentially.
Sure. Do you feel there's anything relevant on
yes.
to the case?
Yes, because one of the legal standards has been that there was an intent to discriminate. We started the case on the theory that this was a discrimination against Democrats. It's like discrimination on the basis of race, but in this case it was discrimination on the basis of partisan identity. That was our theory. And under the law, if you're trying to prove discrimination, you have to prove an intent to discriminate as well as an effective discrimination. It's not enough to show an effective discrimination if you don't also show an intent to discriminate. And so those documents that we were able to recover showed they were trying to discriminate like mad. Through packing and cracking, that's how they did it. But their intent was to get as Republican a legislature as they could possibly get, given Wisconsin's political geography. Our case is just about the state assembly.
Okay, sure that is.
No, I don't think the elections are fixed in the different assembly districts. Just what you will find is the average Democrat gets 70% of the vote or something like that. I don't have the exact statistics. The average successful Democrat. The average successful Republican gets like 60%. Don't quote those numbers, they're not quite right, but that's the proportion. And that's how you create a gerrymander. The Democrats win by supermajorities, the Republicans win by smaller margins. But you take a state that's basically a 50-50 state. I mean, sometimes the Republicans get 51.5% of the vote, sometimes the Democrats get 51.5% of the vote, but that's the range. You take a state like that, and the Democrats are winning by 70%, the Republicans are winning by 60%, you're going to have a lot more Republican winners. just do the arithmetic, you can see it pretty intuitively obvious at that point.
Some have said that Kennedy might be the swing vote here, and he had asked for some clarity in previous cases. How does that relate to this case?
Well, our theory is that what he's looking for, the last big Kennedy opinion was 2004, was essentially better political science. And we think we have it. And the better political science is in two areas. Finding ways to kind of measure how partisan a gerrymander is reliably, so that you can take all the legislative districtings in the country and you can rank them from the least gerrymandered to the most gerrymandered and do it in a reliable way. That is, where you have confidence that it's a sensible ranking. That's important because at some point you're going to set a line and say, if you're on that side of the line, it's bad. If it's that side of the line, we wish you wouldn't gerrymander, but we're not going to say it's unconstitutional. But you want to do it in a kind of consistent way. And we think that social science has developed some metrics since the last case that are reliable. That's a big part of our case. And the second thing that Kennedy is looking for is that these measures are measuring something that's enduring. It's not just something that it's gerrymandered in this case, this year, but in the next year, where some voters may move or, I don't know, something may happen, it'll flip. It'll be consistent over 10 years. And we think social science has developed some ways to predict that pretty reliably. So the record in the trial was full of efforts to establish that we now have measures, and we had wonderful experts that we paid money for. We had to raise money and pay them, political scientists, very distinguished ones. That was a big part of the record.
Is there anything else, just in summary of this case, that you'd like to share?
Well, for me personally, it's been quite the retirement activity. It's been 4 years. I'm kind of proud that it's now become, by consensus, potentially a very important case. How important it'll be, we won't know for a few years for a variety of reasons I won't go into right now. But, it was just 6 guys got together, 1 woman, actually 5 guys and 1 woman got together. Something should be done. Went out looking for lawyers, put together a hodgepodge law firm. It wasn't a law firm, a group of lawyers here, this and that, raised some money from some foundations and got going. And as we were more successful, some of the bigger guns came in, the bigger resources. But it kind of feels organic to start a case that way. It wasn't a case where some big law firm said, there might be a test case here, well, let us take it over. Or some rich guy came in and said, here's some bunch of money, bring a case. We really did it with sticks and glue and whatever, and it feels good, Yeah. And ordinary citizens, like you met Allison Seaton, who was here, just other plaintiffs and other people were involved. In fact, the team, by the time we all gathered in Washington, is 30 or something like that. But really is a great group of people, and everybody played a role, and it was a very nice feeling.
Yeah, well, wonderful, and best of luck to you.
Thank you very much.